This module focuses on the critical importance of transparency, honesty, and full disclosure in all real estate transactions. Arizona law holds real estate professionals to the highest ethical standards, requiring licensees to identify, disclose, and document any situation that could create a conflict of interest or appear to compromise their loyalty to a client. The key takeaway is that disclosure protects everyone: the client, the public, and the licensee's professional reputation. A conflict of interest arises when a licensee's personal, familial, or financial interests could influence or appear to influence their professional judgment. Under ARS Section 32-2 153A3 and Commissioner's Rule R4-2 8-1101F, these conflicts must be disclosed in writing before or at the time of entering into any agreement. For example, if a licensee lists a property owned by a family member, buys property for themselves, or has a financial stake in a referred company, such as a title or inspection firm, they must make that relationship known to all parties in writing. Transparency is non-negotiable in Arizona real estate practice. The module also examined financial interests, marketing service agreements, MSAs, and affiliated business arrangements, AFBAs. These are legitimate business relationships, but must comply with both Arizona regulations and federal law, specifically the Real Estate Settlement Procedures Act, RESP, Section 8. Licensees must disclose in writing any ownership interest, referral fee, or compensation agreement that could affect their impartiality. For example, if a broker owns a share in a title company or receives marketing payments from a lender, the client must be informed through a written affiliated business arrangement disclosure before or at the time of referral. The disclosure must clearly state the relationship, describe any potential benefit to the licensee, and affirm that the client is free to choose any service provider. The final section covered professional conduct in accepting compensation and representing multiple parties. A licensee may not accept payment from more than one party to a transaction without the prior written consent of all parties, as required by R4-28-1101F and Article 7 of the Code of Ethics and Standards of Practice of the NAR. This includes receiving bonuses, incentives, or referral fees from third parties, such as builders or lenders. All compensation sources must be disclosed to clients before signing a contract. In dual or limited representation scenarios, written consent from both buyer and seller is mandatory, using the Consent to Limited Representation form approved by the Arizona Department of Real Estate, ADRE. This ensures that both parties understand the limited nature of representation and consent to the arrangement. Remember that compensation from the seller is now negotiable, and the seller is not obligated to pay any commission to the buyer's agent. Throughout this module, the recurring theme is that disclosure is not optional. It is a professional duty grounded in honesty and fairness. Licensees must always ask themselves, would this situation appear to compromise my loyalty or objectivity if not disclosed? If the answer is yes, or even maybe, that information must be disclosed in writing immediately. Key points to remember: disclose early and in writing. Conflicts of interest, ownership interests, and financial arrangements must be revealed before contracts or referrals occur. Follow RESP and ADRE rules. All affiliated business arrangements and MSAs must reflect fair market value and prohibit referral-based compensation. Obtain written consent. When representing more than one party or receiving multiple sources of compensation, secure written consent from everyone involved. Maintain transaction records. Keep all disclosures and consent forms on file for at least 5 years, as required by ARS Section 32-2151.01. Protect client trust. The foundation of a successful real estate career is integrity. Clients must never question your loyalty or honesty. Summary thought: conflicts of interest are inevitable in a business as interconnected as real estate, but non-disclosure is never acceptable. Arizona law gives licensees the freedom to conduct business, but only within the bounds of complete transparency. By following disclosure laws, maintaining written records, and prioritizing client trust, licensees not only comply with the law, but also elevate the standards of professionalism in the Arizona real estate industry.